Your Honor, I would like to submit into evidence recordings of Your Honor. The courtroom did not erupt. It did not gasp. It simply stopped. Every person in that room, the attorneys, the clerks, the gallery, the bailiff who had worked Courtroom 3 for 11 years, froze in the particular way that people freeze when something happens that their brain cannot immediately categorize as real. The man on the bench, the Honorable Richard Cayne, 61 years old, 22 years. On the federal bench, one of the most respected jurists in the Northern District of Illinois. That man looked at the attorney standing before him and did not speak for 4 full seconds. The attorney was a woman named Claire Odom, 43 years old, senior partner at Odom and Associates. She had practiced in Richard Cayne's courtroom for 11 years. She had won cases in front of him. She had lost cases in front of him. She had exchanged pleasantries with him in courthouse hallways and sat across from him at bar association dinners and believed for most of those 11 years that he was exactly what he appeared to be, a brilliant, principled, and incorruptible judge. She had stopped believing that 14 months ago, and now she was standing in his courtroom in front of his jury, holding a flash drive that contained 63 audio recordings totaling 9 hours and 47 minutes of conversations that Richard Cayne had never expected anyone to hear. Judge Cayne said very quietly, "Ms. Odom, I strongly suggest you think carefully about what you are doing." Claire said, "I have been thinking about it for 14 months, Your Honor. I am done thinking. Stay with us." Because the story of how a trusted attorney came to record her own judge and what those recordings contained is one of the most extraordinary acts of legal courage Sweet Justice has ever covered. Do not go anywhere. Subscribe to Sweet Justice right now. This one starts now, and it does not slow down. Richard Cayne had been appointed to the federal bench at the age of 39, which made him one of the youngest federal judges in Illinois history at the time of his appointment. He had been a prosecutor before that. Aggressive, precise, with a conviction rate that made him a favorite of the United States Attorney's Office and a well-known name in Chicago legal circles before he was 40. His appointment had been praised across party lines. His early years on the bench had confirmed every expectation. He was rigorous. He was fair. He wrote opinions that were cited by other courts. He was, by the consensus of attorneys who practiced before him regularly, the kind of judge you could count on to call it exactly as the law required, regardless of who was in front of him. That reputation was not entirely false. Richard Cayne had been, for a significant portion of his career, genuinely that judge. The corruption had not started as corruption. It had started, as these things often do, as something that looked almost reasonable in the moment it happened. The law firm of Hartwell and Gregg was one of the largest and most powerful firms in Chicago. It had 17 partners, over 200 attorneys, and a client list that included 3 Fortune 500 companies, a major Chicago financial institution, and a network of real estate development interests that touched nearly every significant commercial project in the city over the previous decade. Hartwell and Gregg appeared before Judge Cayne's court regularly, perhaps more regularly than coincidence alone would explain, which was something that Claire Odom had noticed years before she understood what it meant. The relationship between Richard Cayne and Hartwell and Gregg had begun as best as investigators would later reconstruct it, approximately 9 years before Claire walked into that courtroom with a flash drive. It had begun with a dinner, a private dinner, at a restaurant that did not take reservations for ordinary customers, between Cayne and the firm's senior managing partner, a man named Douglas Hartwell. What was said at that dinner was never fully established. But what followed, over the course of the next 9 years, was a pattern so consistent and so financially significant that the word coincidence became eventually impossible to apply to it with a straight face. In cases where Hartwell and Gregg appeared before Judge Cayne's court, the firm's clients prevailed at a rate that was, statistically, extraordinary. Motions that should have been denied were granted. Evidence that should have been admitted was excluded. Scheduling decisions that seemed minor on their face consistently favored Hartwell clients in ways that accumulated over 9 years into outcomes worth hundreds of millions of dollars to the people Hartwell represented. And in the years following particularly significant rulings, Judge Cayne's personal financial picture improved in ways that his judicial salary alone did not explain. A property in Wisconsin, an investment account that grew with unusual speed, a renovation to his primary residence that his neighbors estimated at somewhere between $300,000 and $400,000. None of it was provable. None of it was connected. The property was in his wife's name. The investment account was managed by a third party. The renovation had been paid through a series of personal loans from entities that existed entirely on paper. Richard Cayne was corrupt in the way that very intelligent, very careful people are corrupt, layered, patient, and designed to survive scrutiny. What he had not designed it to survive was Claire Odom. Claire had first appeared before Judge Cayne 11 years. Earlier, 18 months after she opened her own firm following a decade at a large Chicago practice. She was a civil litigator. Complex commercial disputes, breach of contract, occasionally fraud. She was good, she was thorough, and she had the particular quality that the best litigators have, which is not aggression or brilliance but attention. The ability to notice things that do not fit and to hold them in her mind without immediately acting on them, waiting to understand what they meant. What she had noticed, over 11 years of practice in Cayne's court, was a pattern in his rulings that she could not explain on the law alone. She had lost cases in front of him that she believed she should have won, not because she was blind to her own weaknesses, but because the specific rulings that had turned those cases had not been supportable by the case law she had researched. She had attributed it, for years, to the natural unpredictability of judicial discretion. Judges made judgment calls. Not every call went the way you expected. But 14 months ago, something had happened that she could not attribute to judgment calls. She had been litigating a significant breach of contract case, her client, a mid-sized construction company, against a real estate development firm that was represented by Hartwell and Gregg. The case had been strong, the contract language was clear, the breach was documented, and Claire had 3 witnesses whose testimony would have made the damages calculation straightforward. 2 weeks before trial, Judge Cayne had issued a pretrial ruling excluding all 3 witnesses on technical evidentiary grounds that Claire had researched exhaustively and found no legitimate basis for. She had filed an objection. She had requested reconsideration. Both were denied in one-line orders that cited no specific authority. Her client had lost the case, settled for a fraction of what they were owed because without the witnesses the trial was unwinnable. 3 days after the settlement, Claire had received a call from a former colleague who now worked at the Illinois Judicial Inquiry Board. He had called ostensibly to catch up. But at the end of a 20-minute conversation, he had said something that he framed as an offhand comment and that Claire had not been able to stop thinking about since. He said, "You had a rough one with Cayne recently, I heard. You're not the first person to say that about a Hartwell case in his courtroom." He had not said anything more. He had moved the conversation on, but the way he had said it, the specific, careful neutrality of it, told Claire everything she needed to know about what he was not saying. She went back to her office that afternoon and spent 4 hours pulling every case she had litigated before Judge Cayne in 11 years. She cross-referenced every outcome against whether Hartwell and Gregg had appeared on the opposing side. The pattern she found was not subtle. It was not ambiguous. In 11 years, across 19 cases where she had faced Hartwell attorneys in Cayne's court, she had won twice. The industry average for a litigator of her experience and track record was significantly higher than that. She sat with that information for a long time. Then she made a decision that would require 14 months of patience, considerable personal risk, and a level of strategic discipline that most people, including Claire herself, in her more honest moments, were not sure they possessed. She decided to get proof. Subscribe to Sweet Justice right here. Because what Claire Odom did over the next 14 months is something that had never been attempted in the Northern District of Illinois. And the way she did it is the part of this story that changes everything. Claire's plan was not reckless. It was the opposite of reckless. She understood with complete clarity that what she was doing was professionally dangerous, legally complicated, and personally exposing in ways she could not fully predict. She also understood that the only thing more dangerous than doing it was not doing it. Because if Richard Cayne was what she believed he was, every case that came before him was tainted, and every client who sat across from a Hartwell attorney in his courtroom was being robbed by the very system designed to protect them. She started with observation. She began attending hearings in cases she was not involved in. Cayne's courtroom, Hartwell on one side. She took notes. She documented rulings. She cross-referenced them against the case law she looked up afterward. She built a file that grew, over 6 months, into something she could no longer fit in a single binder. Then she made a more dangerous move. She accepted a case that she knew would land before Judge Cayne, against a Hartwell client. She chose it carefully, a client with a genuine, well-documented claim, a case strong enough that any ruling against them would require a visible and specific deviation from settled law. And before the first hearing, she began recording. Illinois is a 2-party consent state for audio recordings in most circumstances. But courthouse hallways, waiting areas, and public proceedings are not governed by the same rules as private conversations. Claire was meticulous about the legal framework. She recorded nothing that was not either public or consented to in ways she documented carefully. She carried a small digital recorder to every courthouse interaction, every hallway exchange, every conference with opposing counsel in the presence of a clerk, every informal sidebar that occurred in a setting that was not explicitly private. And then 4 months into this new case, something happened that she had not anticipated and had not engineered. Douglas Hartwell called her. He said he was calling as a professional courtesy. He said he had heard she was litigating against one of his firm's clients and that he wanted to have a conversation, attorney to attorney, about the possibility of an early resolution. He suggested lunch. Claire said yes. She wore the recorder. What? Douglas Hartwell said over a 90-minute lunch at a restaurant on Michigan Avenue was not by itself a confession. He was too careful for confessions. But it was a masterclass in implication, a sustained, sophisticated conversation in which he made clear, through language that was always technically deniable, that the outcome of cases in certain courtrooms was something he had some influence over, and that influence could work in either direction depending on how cooperative opposing counsel chose to be. He did not say Richard Cayne's name. He did not need to. Claire smiled through the entire lunch. She thanked him for his time. She said she would think about what he had said. She drove back to her office, locked her door, and sat at her desk, shaking for 20 minutes. Then she called the FBI. The investigation that followed was conducted by a 2-agent team from the FBI's Public Corruption Unit, working in coordination with the United States Attorney's Office. Claire provided everything she had: the statistical analysis, the case files, the 6 months of documented rulings, and the lunch recording. The agents listened to the lunch recording twice before they said anything. Then one of them looked at the other and said, "We need to go deeper." What the FBI found over the following 8 months went beyond anything Claire had documented. Financial forensics established the full picture of the payments from Hartwell to Cayne, funneled through the property, the investment account, the renovation loans, and 2 additional mechanisms Claire had not known about, including a series of legal fees paid to a shell company that Cayne's brother-in-law had registered in Nevada. The total value of the corrupt arrangement, over 9 years, was estimated at $4.2 million. They built the case carefully, they waited, and they chose their moment, the trial in which Claire was the opposing attorney, to move. On the morning Claire walked into Courtroom 3 with the flash drive, she had already spoken to the United States Attorney. Federal agents were stationed in the courthouse. The moment she submitted the recordings into evidence, Richard Cayne would be placed under arrest. His courtroom would be sealed. Every case he had presided over in the past 9 years would be subject to review. What nobody had told Claire was whether she would be able to hold it together long enough to actually do it. She had practiced the words. She had rehearsed the moment. But standing in that courtroom, looking at Richard Cayne on his bench, a man she had respected for 11 years, a man she had believed in, she had felt, for exactly 3 seconds, something she had not expected. She had felt sorry for him. Then she had remembered her client. She had remembered every client who had lost in that courtroom against a Hartwell attorney. She had lifted the flash drive and said the words, "Do not move." Subscribe to Sweet Justice right now, because what happened in that courtroom in the 60 seconds after Claire submitted those recordings is something that not even the federal agents stationed outside had fully anticipated. Judge Cayne looked at the flash drive in Claire's hand for a long moment. Then he looked at the gallery. Then he looked at the Hartwell attorney at the opposing counsel table, a man named Philip Grant who had been practicing with the firm for 12 years and whose expression, in that moment, had gone the particular shade of gray that faces go when the floor disappears beneath them. Then Richard Cayne did something that no one expected. He reached forward, picked up his gavel, and said, in a completely controlled voice, "We will take a brief recess." He stood. He stepped down from the bench. He walked toward the door behind the courtroom that led to his chambers. He had taken exactly 4 steps when the door to the courtroom opened and 2 federal agents entered. One of them said, "Judge Cayne, please stop where you are." Cayne stopped. He turned. He looked at the agents. He looked at Claire. And then, in what trial observers who were present would later describe as one of the most surreal moments they had witnessed in a courtroom, he straightened his robe, folded his hands in front of him, and said, "I would like to call my attorney." He was placed under arrest in his own courtroom, in his own robe, in front of his own jury, who sat in the jury box and watched the entire thing in complete silence. Philip Grant, the Hartwell attorney, was placed under arrest 20 minutes later in the courthouse parking garage as he attempted to make a phone call. Douglas Hartwell himself was arrested at his firm's offices the following morning by a team of 4 agents who arrived at 9:15 and escorted him through the lobby of a building whose walls bore his name. The cases that followed were conducted in federal court before a judge appointed specifically for the purpose by the chief judge of the Northern District. The proceedings were complex, lengthy, and deeply damaging to the institutional reputation of the court, damage that the chief judge acknowledged publicly, and that sparked a review of every significant ruling Cayne had issued in the previous 9 years. Richard Cayne's trial began 11 months after his arrest. He pleaded not guilty. His defense team argued that the statistical pattern in his rulings reflected legitimate judicial judgment, that the financial arrangements cited by the prosecution were personal and unrelated to his judicial conduct, and that Claire Odom's recordings had been obtained in ways that raised serious questions about their admissibility. The admissibility argument was the defense's strongest card, and they played it carefully. The pre-trial hearings on the recordings lasted 3 days. The presiding judge, a meticulous woman named the Honorable Sarah Finn, reviewed every recording against the specific legal framework Claire had applied in making them. On the morning of the 4th day, Judge Finn issued her ruling. She said, "The court finds that the recordings were obtained in compliance with applicable Illinois law and federal constitutional standards. They are admitted into evidence in their entirety." Richard Cayne's attorney, a man named Theodore Marsh, stood. He said, "Your Honor, we would like to note our objection for the record." Judge Finn said, "So noted, Mr. Marsh. Sit down." The recordings were played for the jury over 2 full days of testimony, 9 hours and 47 minutes. They heard Richard Cayne's voice in hallway conversations with Douglas Hartwell. They heard the language, careful, indirect, but unmistakable in context, in which rulings were discussed before they were issued. They heard a specific conversation from 8 months before Claire's arrest moment, in which Cayne had said regarding a pending motion in a Hartwell case, "Tell Douglas not to worry about the motion. It will be handled." They heard Douglas Hartwell say in response, "He never worries when it's your courtroom, Richard." The jury heard that exchange played twice. The second time, at the prosecutor's request, played in silence with the transcript displayed on the courtroom screen so that every word was visible as it was heard. Theodore Marsh's cross-examination of Claire was aggressive and thorough. He challenged her motives. He suggested she had embarked on the recording project out of professional grievance, that she was a litigator with a losing record before Cayne, who had constructed a corruption narrative to explain her own failures. He asked her, directly, whether she had ever considered that her own performance in those 19 cases might account for the pattern she believed she had identified. Claire said, Yes, I considered it thoroughly. I eliminated it as an explanation. Before I did anything else, because I know my own work. Theodore asked whether she had discussed her suspicions with anyone before going to the FBI. Claire said she had not, except for the colleague at the Judicial Inquiry Board whose comment had prompted her initial review. Theodore asked for that colleague's name. Claire gave it. Theodore said, "And this colleague, did he provide you with any information from the board's files?" Claire said no. He made a comment. The rest I found myself. Theodore said, "A comment that sent you on a 14-month investigation, the construction of a statistical analysis, a series of recordings, and ultimately a federal criminal referral. Based on one comment." Claire said, "Based on 11 years of paying attention and one comment that told me I wasn't imagining what I had seen." Yes. Theodore had no follow-up to that. He moved on. The jury deliberated for 8 hours. They sent out one question, asking for the transcript of the motion-handling conversation to be provided in writing. Judge Finn sent it in. 3 hours later, they returned. Richard Cayne stood at the defense table in a dark suit, no robe. He had been suspended from the bench the day of his arrest and had not worn the robe since. He was 62 now, a year older than when Claire had held up the CI flash drive. He looked, in that moment, like a man who had spent a year understanding exactly what he had done. The foreperson, a woman named Angela Reyes, a high school science teacher who had taken careful notes every day of the trial, unfolded the verdict form. She looked at it. She looked at Judge Finn. She read, "On count 1, bribery of a public official, we, the jury, find the defendant guilty." Cayne did not close his eyes. He looked straight ahead. "On count 2, honest services fraud, guilty." Theodore Marsh placed a hand on his client's arm. "On count 3, conspiracy to obstruct justice, guilty. On count 4, money laundering, guilty." Angela Reyes folded the verdict form. She looked at the judge. She sat down. Judge Finn sentenced Richard Cayne to 19 years in federal prison. Douglas Hartwell received 14 years. Philip Grant, who had cooperated with investigators after his arrest and provided testimony about the inner workings of the arrangement, received 4 years and was disbarred. The Hartwell and Gregg firm dissolved within 6 months of the verdict, the majority of its remaining partners dispersing to other firms or retiring, none of them eager to carry the name any longer. The 9-year review of Cayne's rulings resulted in the reopening of 11 cases in which his corrupt influence could be specifically established. 7 of those cases were retried. In 5 of the 7 retrials, the outcomes were reversed. Claire Odom never returned to Judge Cayne's courtroom. There was no courtroom to return to. It was reassigned, renumbered, and given a new judge within the year. She did return to the building. She had cases there. She had clients who needed her. She was asked, in a profile published by a Chicago legal journal 8 months after the verdict, what she would have done differently if she could go back to the beginning of the 14 months. She thought about it for a moment. Then she said, "I would have started sooner. I noticed the pattern years before I acted on it. I told myself I was being paranoid. I should have trusted what I saw." She was asked whether she considered herself a whistleblower. She said, "I consider myself a lawyer. This is what lawyers are supposed to do when the system breaks. That is sweet justice in its most difficult form. Not a crime committed by a stranger, not a fraud perpetrated from outside the walls, but a betrayal from inside the institution itself, by a man sworn to uphold the very law he was selling. And the person who stopped it was not a federal agent or an inspector general. It was an attorney who paid attention for 11 years, trusted what she saw, and finally decided that noticing was not enough. Subscribe to Sweet Justice and never miss a story like this one. Share this with someone who needs to hear that the system can still correct itself even when the corruption goes all the way to the bench. Hit that bell. Stay with us. We will see you very soon.